So this morning we are interviewing Denver area patent attorney Mark Trenner. And Mark has been practicing as a patent attorney in Colorado for almost 14 years, and the past 9 years at Trenner Law Firm. While his practice focuses primarily on helping small businesses protect their inventions with patents, Trenner Law Firm assists clients to build out all aspects of their intellectual property portfolio, including copyrights, trademarks, and trade secrets. So Mark, the National Law Review recently published an article titled Design Patent Basics. Aren't all patents for products designs?
Dan, that's a good question, and one that I get all the time. There's actually 3 different types of patent applications that inventors can file for in the United States, and people don't realize that. There's utility patent applications, plant patent applications, like if you come up with a new strain of rose bush, for example. And then, of course, like this article talks about, there's design patent applications.
I didn't realize that. What is a design patent?
In the United States, a design patent protects the unique ornamental appearance of a product, but not its function. So think of a lamp, for example. The function of the lamp is to produce light, usually using an electric light bulb. The common electric light bulb, of course, that might be available in your hardware store can't be patented because it's been around. But if you have a unique design for the lamp, maybe the lamp base or the lamp shade, for example, you might be able to apply for a design patent that covers the way that the lamp shade or the lamp base looks. Or as the article discusses, the design patent can also protect the shape of a bottle or the pattern on the bottom of a tennis shoe, for example.
Okay. So how long is a design patent valid?
A design patent's valid for 14 years from the date of issue. Now, this is different, I want to note, from utility patents, which are valid 20 years from the date of filing. Note that I said date of filing for the utility patent and not date of issue as for the design patent.
Good point. I see that the article says design patents are often a forgotten form of intellectual property despite the fact that they've been available to inventors and designers for over 150 years. Why are these so often overlooked?
Well, design patents really offer a different type of protection than utility patents. Often, design patents are seen as offering less protection than utility patents. But the key here is really different, not necessarily less protection.
What do you mean by different protection?
Well, it's important to understand that design patents only protect the ornamental appearance, and that's exactly as you picture it in the drawings in the patent application. Nothing more, maybe some trivial variations, but really nothing more than that. So design patents are often said to offer less protection than utility patents.
But you said the design patents offer different protection, not necessarily less protection.
That's right. The article makes a good point that design patents can be very valuable. The article points out as good examples Apple iPhone's graphics, their graphical interface, and the original Coca-Cola bottle, for example. The article also points out that design patents are a cost-effective way to protect intellectual property for companies and businesses. I'd add that design patent applications are often examined much faster than utility patent applications, and therefore they may issue as enforceable patents long before a utility patent is examined or even issues.
Huh. So which type of patent application, design or utility, should inventors consider?
Well, the article points out that a collection of design patents can significantly increase the selling price of a company. But really, it's going to depend on the particular invention and what aspects are important to protect.
So does the article offer any tips for design patent applications?
Yeah, but the article does. They suggest filing more than one design patent application, for example, at least if it's in the budget, each covering a different aspect of the design. The article also discusses the importance of getting the drawings right to avoid rejection.
Any other tips?
Well, the article also suggests proper use of surface shading in the drawings, and that even just changing the surface shading after the initial filing could be considered new matter, and therefore the patent office examiner might reject the entire application.
That sounds kind of technical. How does an inventor go about finding out all of the drawing requirements to file a design patent application?
Well, that's really why it's important to work with a patent attorney and not attempt to file a design patent application on your own. There's a lot of mistakes that you can make, and like I said, the examiner might reject it outright, and you never get the patent to issue. If you make mistakes during the initial filing, then you go to a patent attorney to help you out. It might be too late. The patent attorney might not be able to do anything to help you at that point.
Gotcha. Well, thank you, Mark. That's all the time we have for today. For more information, be sure to visit Trenner Law Firm's website at www.us-patentattorney.com. And for just one of his blogs, you can find him at ipatentattorney.org. Thanks again, and we'll talk to you soon.
Thanks, Dan.